Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. I'm here with Ann Lipton, a law professor at Tulane in New Orleans. She teaches and researches securities and business law, and she holds up the legal end of our podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Yes, thanks. Well, Ann, lots to work on today. Couple subjects. Both of us have thought and written extensively about Tesla. It'd be interesting and fun to look at what happened there in the last few weeks.
Also, we just finished a second year of annual shareholder meetings and board director votes under universal proxy, and we can look back on what we've learned in the past few months.
All right, that'll be fun. Let's start with Tesla, though. Earlier this month, there was a hearing about a particular matter involving Tesla and Elon Musk's compensation. Why don't you briefly describe for us what that hearing concerned?
Okay, so as the world knows at this point, earlier this year, Chancellor McCormick ruled that Elon Musk's $54 billion pay package paid in Tesla stock represented a breach of fiduciary duty by Musk and the Tesla board. She found that when the board approved this much pay for him, it was under Musk's thumb. And when shareholders voted in favor of it, which they did back in 2018, but they were misled. They didn't have sufficient information in the proxy statement. So she ordered that the whole pay package be rescinded. Now that decision is going to be appealed to the Delaware Supreme Court, no question. So her findings are going to be reviewed. But before that happens, Tesla wanted to belt and suspender it by holding a second shareholder vote on the pay package, on the theory that if shareholders approve it again, this time there can be no doubt this is what shareholders want. They had full information. So Tesla put the pay package, yeah.
So there was a hearing. So there was the hearing in Delaware about this vote. Go ahead. I'm sorry.
Yeah. So exactly. So the Tesla put the pay package to a shareholder vote again. The shareholders voted in favor of it again, and Tesla is back before Chancellor McCormick, and they're saying, "See, we did it right this time. You should modify your original order and give the money back." But there's still this plaintiff who challenged it originally, and Richard Tornetta, and he's arguing through his attorneys that the new vote has no effect, and therefore the original verdict stands. And that's what this hearing was about. Does the new shareholder vote restore Musk's pay?
Got it. So the hearing took place, and what was Tesla arguing about?
Well, Tesla's argument, their argument's really, it's very simple. It's originally she rescinded the pay package because Elon Musk controlled the board of directors who authorized it, and because the shareholder vote in favor was based on this misleading proxy statement. And Tesla says, we fixed all of it. A new independent director who wasn't on the board when the original package was granted, she reviewed everything, she recommended the pay package be instated, and now fully informed shareholders voted to ratify it. They had the old opinion in front of them. They knew all there was to know. Done and done. That's Tesla's argument.
So Tesla, I'm a Tesla shareholder. So I received the proxy statement for the shareholder meeting, which was in June.
It was April.
And
the price statement.
The shareholder meeting was in June. They first sent out the proxy materials in April, and those proxy materials included a 200-page opinion.
Yeah.
From Chancellor McCormick.
We're not hiding anything. You can see everything that she found. So there's no argument that anybody was misled about anything. That's their claim.
Right. So what did the plaintiffs say to that? What was their argument? And their argument is subtle and technical, I understand, but it's really worth trying to understand.
It's not. Yeah. It really isn't that technical. I mean, there are different aspects to it, but their arguments basically boil down to that's not how any of this works. The chancellor already concluded that the original pay package was tainted by fiduciary breaches, and you can't just fix all of that with a do-over. This isn't something shareholders can override post-trial. You can sort of back into this. So there's plenty of reasons to question this new vote. The single director is receiving over $100 million in Tesla stock, which means she's very reliant on maintaining her position and staying in Elon Musk's good graces. So maybe we can't trust this new director either. And the shareholder vote may have been coerced in the sense that Musk more or less explicitly threatened shareholders that if they didn't approve his compensation this time, he'd steal Tesla's data and develop artificial intelligence in his private XAI company. company. So if the shareholders were coerced or the new director really wasn't independent, then you can't take the new vote at face value. Nothing was fixed. So that's, basically their argument.
Got it. All right. So there's this clash of arguments. Tesla's saying we now have a vote that I love the Delaware terminology that I'm familiar with, that the new vote cleansed the earlier decision. And the plaintiff, Tornado, the drummer, are arguing, or his lawyers arguing, that no way, you can't vote. Shareholder vote can't override a breach of fiduciary duty, and can't override Delaware statute.
Right. Well, it can't override a breach of fiduciary duty that's already been adjudicated.
Right. Oh,
that's if they wanted
point.
to fix it, they should have done it before trial, not after.
Right. Now, what was the idea that's been thrown around that if another part of the coercion, basically the second vote was, Tesla shareholders like me, our hands were tied. There was another part of this about the new grant. If Tesla were to go back, and what did that have to do with it?
So one of the weirder things about this situation is Tesla's argument is this restores the old pay package. It's the exact same pay package that the Chancellor McCormick took it away, and we're just giving it back to him. That's what.
And that was from 2018. It was granted, right?
2018.
It was from 6 years ago. Okay, got it.
Exactly. Because when they granted it to him in 2018, it was just this option. It was if you hit certain milestones in the stock, you get this stock. And they want to give the old pay package back. Literally nothing is stopping them. Absolutely nothing. From today, saying, all right, fine, the old pay package is gone. She took it away. We're awarding Elon Musk, our CEO, a whole new pay package, a 2024 pay package of $54 billion. Now that Tesla has reincorporated to Texas, they're a Texas company, the fiduciary obligations, if it was challenged, would be adjudicated under Texas law. Yeah. Nothing is stopping Tesla from saying, give Elon Musk $56 billion today. And of course, but Tesla doesn't want to do that because that would incur all kinds of tax liability for Elon Musk, different tax liability, and it would be an expense on Tesla's balance sheet that would be very bad for the company. And so part of the coercion, so this explains why they wanted to go back and do over 2018 rather than give him a new pay package. But also it's part of the coercion argument, like Tesla suggesting, if you don't ratify it, that is what we'll do. We'll give him $56 billion today, and won't that be terrible for the company and the value of the company? So that was another argument as to how shareholders were being coerced, that they were being told, if you don't ratify the old award, which looks better as an accounting matter, we'll give him a new award, which works worse as an accounting matter.
Right. So instead of the $2 million fair value, grant date fair value.
Exactly. From
late
2018. $2 billion grant value. 2018.
Billion with a B. Instead, this year, the number was closer to like 25 billion with a B charge. And that's that much I know is that would soak up the last several years of like Tesla's accounting profits.
Yeah, exactly. So it was really saying we're going to give them the same stock one way or the other. It's just it can have a horrible accounting charge or not a horrible accounting charge. Exactly. Shareholders, it's your choice. So that was another argument for why this was coerced.
Right, and shareholders, they did approve it. They knew all this.
They did approve it. So, I mean, there are all kinds of subsidiary arguments. I mean, the plaintiffs are saying, look, do we know the new proxy was fully truthful? We don't know that, again, because we don't know if this new director was fully independent. So they definitely approved it knowing the financial terms, but whether everything else was disclosed.
all the relationships and all the love for Elon that was not disclosed in 2018 that presumably was disclosed now.
Yeah, but we don't know, but the plaintiffs, I'm pretty sure, would not concede everything that we know, everything there is to know about the new director and so forth.
So what did Chancellor McCormick of the Delaware Chancery Court think, or what do we think she thought about what she heard?
Okay, so obviously, until she rules, we won't know for sure. But she did express a lot of skepticism of Tesla. And the idea being that nothing's ever been done like this. There's no case where after a judgment by a court that there's been a breach of fiduciary duty, the defendants went back and said, wait, we'll hold a new vote and do the same thing again. And from a practical perspective, the problem boils down to this. As we said, Tesla's position is now the new shareholder vote is fully informed. But the plaintiff's position is we don't know that. Tesla's position is this was fully and a free vote. But the plaintiff's position is this new vote was coerced. The only
Right.
way you can determine that is by having a whole new trial to see if the second vote was fair. And so
She
ultimately the
doesn't
question
want
is,
that.
how many times are you going to try this one case? That's
Right.
why you should do this before the trial, so that if
Right.
you want to have a whole second vote, that can all be tried at the same time.
She
and I
has
think
seen
that
lots of Musk. She does not want to see him again.
exactly, and I think that that is ultimately, sort of her concern, that that you'd have to start all over again and just keep trying the same case over and over, and not just. Or if you think about it this way, right? Originally, there were two parties that were interested, sort of like it was the stockholders, the plaintiffs, versus Tesla and Elon Musk. But now there's a third interested party. That third interested party is the court. The court is concerned about its own judicial resources, its own time and effort, and that's real. Like, courts really do care about making sure that things are handled efficiently, and they aren't as unnecessary skirmishing and so forth. And now you've wasted the court's time. And that's very valuable to the court. So the court, she seemed to think, and we won't know for sure, that Tesla had its chance, and if it wanted to get this right with a shareholder vote, the time to do that was earlier, and it's too late now. But and now after trial, that it's stuck with that, and all it can do is appeal. And so we'll see if that's actually how she'd hold. But that seemed to be how she seemed to be leaning.
And any guess at what, or from yourself, or what the other observers think how she'll handle this? Is she just gonna?
Yeah, I mean, I find it hard to believe that she would simply accept the new vote at face value, because I think there are enough questions raised about it. So that would mean either she has to say, you can't do this at all, we're done, or she has to hold some kind of hearing, whether there was coercion, whether the new director was independent, something. Because it's very hard for me to believe, and maybe I'm wrong, but it's hard for me to believe that she would take this new situation. I mean, the claim of coercion is quite colorable. So it seems very difficult that the new vote would be taken at face value, and she'd just say, whoops, okay, I got it wrong, we're all done, I give it back.
Right. But so she may have to, unlikely, given your observations about judicial resources, unlikely she's going to want to hear a lot more facts about this next vote. She may just say, let's let the next court hear it.
Well, she might the appellate court, like basically I think,
or the Supreme Court,
the more likely. It seems to me that the easiest path for her is to simply say you don't get a do-over, and then let the whole thing.
And do you is that roughly how you would, the direction you might want to take? I mean, what do you think is the right, based on your understanding of the law and the facts?
Well, I definitely think the law is against Tesla here. So, I mean, all kinds, I think that the claim of coercion is quite strong. There may be all kinds of reasons to question the independence of directors, and you can't, I think that it just doesn't make sense to create a rule that says you can have endless trials over the same thing. But, so I think that from a legal perspective, existing law is against Tesla and Elon Musk here. But that raises the bigger question, whether this entire system does in fact serve shareholders, because it's also very clear that Musk and Tesla almost certainly violated like every technical standard Delaware has as far as how a CEO and chair or former chair should conduct himself. But Tesla shareholders still love him. We can argue about the technical standards for what counts as coercion or not, but what's also true is that Tesla shareholders really like Elon Musk.
They really want to pay him this money.
Yeah, so
Tesla... They want to find a way, yeah, right.
So there's a conundrum for Delaware law itself, and it really begs the question whether these standards are in fact the right standards for Tesla. And maybe that means Tesla was right to move to Texas, where probably the same standards don't apply.
Right. Wow. All right. So next move is probably almost likely we'll hear a ruling from Chancellor McCormick, hopefully sometime soon.
Yeah. I mean, I would imagine within the next 30 days or so. Right. But I don't want to put it in blood, but it shouldn't take that long. But she also has to settle on attorney's fees. And once she makes that ruling, assuming she doesn't hold a hearing, assuming it ends because she says the new vote doesn't matter, and then she just awards attorney's fees, then there's going to be an appeal. Like once we're done in Chancery, whatever she holds, once she's completed her findings, then it gets appealed. And then straight to the Delaware Supreme Court, there's no intermediate step. And the Delaware Supreme Court will get hold of, was she right originally, which it hasn't weighed in on? Yeah. Was she right, whatever she holds, about the new vote? And was she right about attorney's fees?
About the original hearing too.
Yeah,
the original
exactly.
opinion.
And if it decides the original decision was wrong, it doesn't have to worry about whether a new vote matters. And if it decides the new vote cured whatever problems may have existed, it doesn't have to ask whether the original finding,
Right.
So there are a lot of paths
Right.
the Delaware Supreme Court can go.
And how long will that take, do we think?
At least a year. I mean, this is just not going to be
Oh
settled.
my gosh.
I mean, there's no
us-
rush now. I mean, it's not like there's a pending deal on the table.
No,
so.
that's true. All right, cool. Hey, this is quite cool. All right, let's take a quick break, and we will return in a minute to talk about universal proxy here at Shareholder Primacy.
This is the Free Flow Media Podcast Network, where we cover the who of the business news, because investing isn't a what, it's a who. Check out our other podcast, Business Pants, for fact-based snark covering companies and executives, and the Proxy Countdown, the only podcast that treats company meetings like sporting events. Find them on iTunes, Spotify, or wherever you get your podcasts. Back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin. So, Mike, let's talk about universal proxy. And as a refresher, what is universal proxy?
The universal proxy, that's the age-old question. It is a way, strictly speaking, the short answer to your question, it's a way for shareholders to cast votes for corporate directors in the U.S. in director elections. So once a year in public companies, everyone gets to vote on who their directors are. And universal proxy is just a means of displaying the names of the people who you're voting on. But it's a lot deeper than that. So what happened was a couple years ago, starting in really the beginning of 2023, the SEC required companies to start implementing this means of showing how proxies look in the US.
So wait, so what was the rule
Yeah.
before the SEC
right.
changed it?
So for years or decades, the way corporate elections worked was that a company, and this is only when there's what's it's called a contested election. Most elections, it's just a bunch of incumbents that the company just designates.
Yeah, there's
everybody
just
votes
no
for
dispute.
those, and there's no dispute and so forth. In a handful, in somewhere between 10 to 30 companies a year, an activist like me goes in and nominates. Sometimes it's called dissidents. Sometimes competing directors. So there's more directors running for the available seats.
So the activist they think these people should be directors, and the
Exactly.
board, the incumbent company, they say no, our existing directors are fine.
Right. So the way it used to work, suppose we have a board of 10 people. Okay, an activist could nominate 10. It's unusual. So you'd have 20 people, 10 for the company, 10 for the activist, running for 20 people running for 10 seats. Or what usually happens is the activist will nominate fewer than 10. Let's say 3 out of 10. So then there'll be 13 people to choose from running out of 10. Well, before universal proxy, the way it used to work, that's a great question, is that you could either vote for all 10 of the company's nominees or just for 3 of the activists' nominees. You had to pick one or the other. So vote for 10 or vote for 3. And then at the end of the day, they'd add up, and the 10 out of the 13 that got the most votes would be declared the winner.
So it would be, and this is because the shareholder literally got a physical card, physical ballot.
Oh yeah, right, exactly. And there was always this fun deal between the white card and the pink card or something.
Yeah, so they got competing ballots from each side, and each one would list only their candidates, and you had to return one or the other, so you couldn't
exactly
match.
right. And you could, if you were a really determined shareholder and you wanted to vote for only 2 of the activists and 8 in our example of the company, you could go to the trouble of getting the right legal paperwork together and submitting your own letter and so forth, and almost nobody ever did that. So it was just an either or situation. Well, University of Proxy changed that dramatically and allowed shareholders, just voting shareholders, to kind of pick and choose. So the practical effect, we'll go into the mechanical change in a minute, but the practical effect was to literally allow, in our example of 10 and 3, a shareholder to pick one of the shareholder nominees, activist nominees, and 9 of the company nominees, or 3 and 7 or whatever. Yeah.
And this is because the ballots all have all the names of all the people running instead of just one group's ballot or the other group's ballot.
Right. So when if you're a voting shareholder, and again, it seems like a really arcane change, but we'll talk about some of the reverberations.
It seems like an obvious change that
should
have happened forever ago. Like, why would you get like 2 different ballots that have different names on them? And
there's activists that have been agitating for this for years. It's just totally sensible, and it finally took the SEC a long time to get their act together to do it. But used to, now if you get the company's white ballot, or proxy card as we call it, it will list all 13 people. And if you get the activist's blue one, it'll list all 13 people. So it doesn't matter which one of the 2 that you pick, that you submit, that you send in. And we talk about this as it being mailed, but it's all done electronically these days. But then you can sort of pick and choose. You could, if you don't like anybody, you want to only vote for 2 people out of 13, you can do that too. Vote for one of the companies and one of the activists. If you totally like how the company's going, you think the activist is full of baloney, you can still vote for all 10. If you like everything the activist is doing and can't stand the company, even though you're still a shareholder, you could vote for their 3, the activist 3, and vote for none. So you have a lot more flexibility to tailor how you vote, and you can calibrate your vote to sort of the degree of change that you want. So if you really, really are unhappy at the company, you could vote for all 3 of the activists' candidates, none of the companies, and wish the activist nominated 7 more.
Yeah.
Okay, if you only want sort of some change, you could vote for 2 of the activists and 8 of the companies. So anyway, so this is kind of the practical impact that this has had, and it's actually reverberated in some really kind of cool ways.
Yeah.
For
So
activists.
exactly. So what are the implications? Like how are people running proxy contests now?
Okay, that's a great question. First, proxy contests have become a lot more personal. Okay, it used to be that you would you'd vote kind of the company or the activist, because it was all or nothing. Either you supported the company's case that even though our stock is down, we got a good plan and just have faith in us, or you'd have to vote for the activist case that throw the bums out. They're all a bunch of losers. Vote for all of our people. Okay. Now you can compare and contrast individual candidates a lot better. Okay, so in fact, shrewd activists not only, in our example of 10 and 3, not only identify, nominate the 3, they have to do that, but they'll identify the 3 company incumbents that they want to target. The kind of voting math and voting logic, which we don't have to delve into here, suggests that an activist will maximize its results by targeting, by trying to guide the shareholders to voting against 3 specific incumbents. And so you're in a situation where a lot of proxy materials, a lot of the stuff that's being sent to shareholders by the companies and the activists is getting kind of personal. We're saying, okay, here's the 3 that we like, and here's the 3 that incumbents that need to go. And here's the reasons why. Because this person's been on the board too long. Because this one's in the pocket of the management. Because this one has no expertise, for the committee they're on or whatever. And it gets a lot more touchy, I suppose. But that's expected, because you're helping people not just choose between the company's case and the activist thesis, but choose among all these candidates so you can pick and choose. That's one of the first serious implications. The second has to do with companies and activists, but really companies, wanting to avoid dealing with universal proxy in the first place. Okay, we're only in the second year of this. It's still being kind of tried out in a sense about how it works. And I followed, a bunch of contests to sort of see how the actual voting actually outcomes look. And companies in particular really want to avoid seeing that. So settlements of these contests have increased dramatically in the past 2 years. That companies, that there's a much greater percentage of activist proxy contests are settling, and they're also settling quickly. I think the time to settlement, based on various measurements, like twice as fast.
Wow.
As it's been before.
That's funny.
Yeah. Because no company wants to be on the wrong end of it, and there's been some where activists have won everything. There was a couple smaller contests this year. Parks America was one. Another one was LL Flooring, the old lumber liquidators, where activists came in and won every seat they were looking for. And that tends to be, in previous years, that would have been a very unusual outcome. And for 2 out of the 14 or 15 I've looked at, to work out that way would be considered a little unusual. So companies don't even want to get there. So they've been settling these and giving activists some or a lot of what they were looking for. So that was one of the implications. One of the things that didn't happen that's worth mentioning, it was thought that a universal proxy would make proxy contest a lot easier, a lot cheaper, and it actually. Because the company is showing the names of your activists, you can do a lot less solicitation and so forth. There's a lot we can go into, but essentially the sentiment was, oh man, this is going to make it a lot easier for activists to do proxy contests. And sort of it reminds us that you don't have to spend a lot of money to run a proxy contest, but you really do need to spend some money to win. Right. And we just did an analysis in the past week or two that showed that proxy contests are costing more than ever. Wow. The Disney contest, which was the biggie, cost the party $71 million.
Yeah, because that had 3 different, the incumbent and 2 different challengers. So the card was just full of names.
Yeah, it was very intricate. And that one, Trian nominated 2 candidates, Nelson Peltz and then the former CEO of Disney, Jay Rasulo. And Trian and neither candidate, they got some votes. They did, respectably well. But they didn't win. That was unbelievably expensive. So anyway, go ahead.
So what do you see upcoming then, if that's what the incentives are now?
Yeah. Well, we thought there'd be a lot more kind of newer single issue activists that wanted to kind of push an agenda. We didn't really see that in the first year. We only saw one example of that this year. That was Starbucks ran a proxy contest for 3, trying to nominate 3 labor-friendly, the union, SEIU, tried to nominate 3 labor-friendly activists, candidates, and they walked away from that contest. It was getting costly, and Starbucks looked like they were going to win. We may see a little more of that, finally. But I'm expecting just a continuation, a lot more settlements. Right now, there's a couple of kind of pending contests already. Elliott has announced the intent to try to basically replace all or most of the board at Southwest Airlines.
Right.
That'll be run, assuming it gets that far.
Yeah.
And Southwest seems determined, and Elliott is not someone to
it's
take
so
lightly.
interesting because when you're running, it occurs to me that when you're running a full contest, for the full board, your thesis is, I need to take over. None of these people, all of them need to go. And that seems to be the case where if shareholder, as opposed to a short slate when you're only running a 2 or 3, so it makes sense. There, it makes more sense for a shareholder voting to pick and choose. You ran 3 candidates, and I like these 2, but not the third one, and I think those 2 can get, a fresh voice on the board. But if it's so weird to think of Elliott running, say, a full replace the board, and what if universal proxy means they only get 3 seats? It seems like a mix and match in that scenario is very odd.
Yeah, and that actually happened. So Elliott has a precedent to look at. That happened at Norfolk and Southern this year.
Oh, right.
A very experienced activist named Ancora out of Cleveland ran, Norfolk Southern's had a lot of problems. They're the ones who were responsible for that huge accident in Ohio and so forth. Anyway, Ancora nominated 8, I think, out of 12 or 13 directors, looking for majority.
So they want a majority, yeah.
And they looked for it, but they won only 3 seats.
That has got to be...
that might have
interesting
been a
in the
little
boardroom.
discouraging. Yeah, right. There's three. It's not just one. It's not just some lonely person. It's three people in the Norfolk and Southern boardroom that were, they didn't want to be there. The rest of the board didn't want them there. But it's not nearly enough to exert any kind of control.
Yeah, so it's shareholders
over the
saying,
company.
we want you to think about new ideas, but we really don't need a wholesale,
Exactly, right.
Okay.
So anyway, there'll be more of that. Again, there's even a couple of contests already that are in process, including this one at Southwest, that will be worth following even before the 2025, as we say, proxy season kind of gets underway. So this will be kind of cool to sort of see how it continues to affect these contests. Probably a lot more settlements. I would expect Southwest and Elliott to get to some sort of compromise. I mean, no one wants to spend the kind of money that is possible here. But who knows? So.
Okay. All right. Well, let's wrap up there. There's more we'll cover next time.
Yes. Thanks, Ann. It's been terrific talking about these subjects. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is the Michael M. Fleischman Professor in Business Law and Entrepreneurship at Tulane Law School and also an affiliate of Tulane's Murphy Institute. You can find me, Mike, at theactivistinvestor.com, and you can find Ann at law.tulane.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening, and we'll talk again soon.